Hello friends, I am Mayank Mohanka, partner in Messrs S M Mohanka and Associates, founder director in Taxmann India Private Limited, and an author of the bestseller professional book Faceless Assessments, Appeals and Penalties Ready Reckoner with real-time case studies with Taxmann publications. Friends, in this bite, I am trying to capture all the nuances and practical implications of the Hon'ble Supreme Court judgment on the validity of old reassessment notices issued on or after 1st of April 2021 and up till 30th June 2021. Friends, I will also try to answer in very clear and unambiguous terms as to which all notices will survive and which will not survive after taking into account the directions and the mandate of the Hon'ble Supreme Court in this judgment. So let's begin it. Friends, on 4th of May 2022, the Hon'ble Supreme Court, in a batch of civil cases with the Union of India versus Ashish Agarwal as the lead case, has upheld the validity of such impugned reassessment notices issued under unamended Section 148, but on or after 1st of April 2021 and up till 30th of June 2021. Friends, we all know that the Honorable High Courts across on pan-India basis, more specifically the Honorable High Court of Allahabad, Delhi, Rajasthan, Calcutta, Madras and Bombay, in their respective petitions have quashed such reassessment notices, holding them to be void ab initio and on various grounds, the main ground being that delegated legislation cannot overreach principal legislation because these impugned notices, reassessment notices, were being issued after the deadline of 31st March 2021, and the assessing authorities has relied upon the explanations to the TOLA Act, that is Taxation and Other Laws, Relaxation and Other Amendments, Certain Provisions Act, more popularly known as TOLA. So the Honorable High Courts have quashed such notices, and the decision of the Honorable Allahabad High Court in the case of Ashok Agarwal, the revenue authorities have filed an SLP, and it was against this SLP, which this judgment of Ashish Agarwal has been rendered by the Hon'ble Supreme Court. Friends, in this judgment, the Hon'ble Supreme Court has invoked Article 142 of the Constitution of India to decree to provide complete justice, and probably for the first time in interpretation of a tax law or a tax provision, this Article 142 special power has been exercised by the Hon'ble Supreme Court. And in this judgment, the Hon'ble Supreme Court has held that all such 148 notices shall be considered as deemed notices under Section 148A, that is the new Section 148A, applicable as per the amended provisions of Finance Act 2021. To be more specific, the Hon'ble Supreme Court has held that such notices under Section 148 shall now be considered as deemed show cause notices under Section 148A, Clause B of the Income Tax Act as per the Finance Act 2021. And the assessing authorities are supposed to provide and communicate all the information which they are having in their possession, on the basis of which such reassessments are proposed to be reopened. So within 30 days from 4th of May 2022, which effectively means from up till 2nd of June 2022, the assessing authorities are supposed to provide all the relevant information and material which they are having with them in order to propose the reopening of such cases. And the Hon'ble Supreme Court has also provided that after the receipt of such information or material, the assessees are then required to submit their objections or replies within a period of 2 weeks. And on receipt of such replies or objections from the assessees within a period of 2 weeks, then the assessing authorities are required to pass the order under Section 148A, subclause D, after getting the prior approval of the competent income tax authorities. And if suitable, if found appropriate, then the fresh notices under Section 148 shall be issued in consequence of such deemed notices under Section 148A. So this is the entire scheme of things which the Honorable Supreme Court has provided and mandated in this judgment. Friends, now coming to the most important and practical aspect, that which all reassessment notices will survive and which all reassessment notices are still amenable to be considered as invalid. Friends, 5 assessment years are in question. That is assessment year 13-14, 14-15, 15-16, 16-17, and 17-18. And out of these 5 assessment years, the assessment year 13-14 and assessment year 14-15, in my humble understanding, are amenable to be considered as invalid notices by virtue of first proviso to section 149, which provides grandfathering protection to these 2 years. Friends, uh, in this judgment only, the Honorable Supreme Court has categorically mandated that these notices shall be considered as valid notices and as deemed notices, show cause notices under section 148A. But at the same time, the Honorable Supreme Court has also categorically directed and mandated that all the provisions applicable as per the amended provisions of the Finance Act 2022, including the time limitations as per the amended provisions of section 149, shall be applicable on such notices. So this in turn implies that all the amended provisions of section 147 till 151 as brought about by the Finance Act 2021 will be applicable, and section 149 of the amended income tax provision as per the Finance Act 2021 clearly provides that first of all, the notices which could not have been issued on or after 1st of April 2021 for the assessment years, taking into account the previous 6 years criteria, which means that assessment year 13-14 and assessment year 14-15 could not have been issued on or after 1st of April 2021 because of this first proviso to section 149. Now coming to the principal time limits which are provided in section 149. Friends, 2 time limits are provided. First is that the notices can be issued within a period of 3 years from the end of the relevant assessment year, which means that the notices can be issued on or after 1st of April 2021 up till from assessment year 18-19 and onwards, and not before. But however, there is one rider, that is this 3-year time limit will be applicable only if the escaped income is less than rupees 50 lakhs in a year. However, if the escaped income is more than rupees 50 lakhs in an assessment year, then there is another condition that the such assessment years notices under section 148 can be issued up till 10 assessment years, up to cover previous 10 assessment years. So going by this, up till assessment year 11-12 can be issued on or after 1st of April 2021. But as I have already mentioned, that this first proviso to section 149 clearly mandates that assessment year 11-12, assessment year 12-13, assessment year 13-14, and assessment year 14-15 notices, reassessment notices cannot be issued on or after 1st of April 2021. So now the clear picture which emerges is assessment year 13-14 and assessment year 14-15, in my humble understanding, shall be considered as invalid by virtue of first proviso to section 149 as per the amended provisions in Finance Act 2021. Friends, here I would also like to add that there is some confusion in some quarters regarding an apprehension that this time limit has been changed. This first proviso has been amended by Finance Act 2022, but it is not so, friends. Even in Finance Act 2022, the first proviso to section 149 clearly still provides that protection shall be provided to assessment year 13-14 and 14-15. So assessment year 13-14 and assessment year 14-15 shall be considered as invalid even after giving consideration of the Honorable Supreme Court judgment. Now coming to assessment year 15-16, 16-17, and 17-18. So friends, for assessment year 15-16, 16-17, and 17-18, as I have already mentioned, that the new time period, if the escaped income is less than or equal to 50 lakhs, then up till assessment 1718, no reassessment notices can be issued in the new section 148 with effect from 1st of April 2021. So in cases if the escaped income or the alleged escape income is less than rupees 50 lakhs in an assessment year, then this three assessment years, that is assessment year 1516, 1617, and 1718, shall also be considered as invalid. And however, if the amount of alleged escape income is in excess of rupees 50 lakhs in an assessment year, then obviously these notices are amenable to be proceeded further. But then also there is one more further condition. Friends, we need to here understand that in the erstwhile provision before 1st of April 2021, as per the Finance Act 2020, the mandatory condition for invoking this reassessment power was the formation of independent reason to believe that income has escaped assessment by the jurisdictional AO. But now, in this Finance Act 2021, this mandatory condition of formation of reason to believe has been replaced with possession of an information with the assessing authority as per the risk management strategy of the CBDT and the final audit objection of the Comptroller and Auditor General of India. Friends, these two conditions, that is the possession of information as per the risk management strategy of CBDT or as per the final audit objection of C and AG, which suggest that any income has escaped assessment, were incorporated by Finance Act 2021. And and these notices these notices under consideration, since these have been issued on or after 1st of April 2021 and up to 30th of June 2021, therefore the provisions of Finance Act 2021 shall be applicable and the provisions of Finance Act 2022 shall not be applicable. And so therefore the relaxation, the further extension in the coverage of the meaning of the term information, so as to include any audit objection, including the internal audit objection, as well as the exchange, any information received pursuant to a foreign exchange network or agreement with the countries, and any audit objection, and not just the final objection of C and AG, that is audit objection of internal audit department also. This criteria has been broadened by the Finance Act 2022, and the further for reopening the cases beyond 3 years and up to 10 years, there is one more relaxation in Finance Act 2022. That is the threshold limit of 50 lakhs has to be considered in all the years and not just one assessment year. But I am again telling you that this extended definition of information, as well as extended and liberal criteria of spreading up of this 50 lakhs income in 10 years, shall not be applicable on such notices, because these have been already issued on or after 1st of April 2021 and up to 30th of June 2021. Therefore, the provisions of Finance Act 2021 shall be applicable and not the provisions of Finance Act 2022. So, if the amount of escaped income is less than rupees 50 lakhs in any of such assessment year, then the assessment year 1516, 1617, and 1718 are also amenable to be considered as invalid. However, if the alleged escape income is more than rupees 50 lakhs in each of such assessment year, then the assessing authorities can proceed. But still, in my humble understanding, then also the assessees should, because now the assessees have to file their objections, so it is very important for them to ask for the particularly as to on what basis such reassessment or proceedings have been initiated, and if on receipt of such information it can be established that such was not the reopenings have not been initiated on the basis of any information or possession of information as per the risk management strategy or as per the final audit objection of the CBDT. Say, for instance, the notice, any information has been received from another income tax authority or from the investigation wing. So it is questionable that whether these will also get covered under the new definition of information or not. So in my humble understanding, they should not be covered. So even if the amount of alleged escape income is in excess of rupees 50 lakhs in each of such assessment year, then also the assessee should file their objections and ask for the relevant basis. And if they are able to establish that these reopenings are not on the basis of any information, on the basis of risk management strategy of the CBDT or the final audit objection, then also such notices are amenable to be questioned, in my humble understanding. So friends, this was a little bit about all the practical aspects. I hope that you will find this discussion useful and practical, and will proceed, because now we have to proceed. In fact, you would be probably be getting the notices, and you should ask, if you are in receipt of any such notices, then immediately you should ask, file your objections and ask for the relevant material. And based on our discussion just now, you should file your objections or replies or ask for further information, on the basis of which such reassessment proceedings have been initiated. So kindly do that within the time period, specified time period. So friends, this was all about it, and I hope you will find it practical and useful. Thanks. Take care.